Well, sure, in theory. I mean, let me take two examples of what, the things that the court has struck in the past under the Commerce Clause. There is the school-free zones statute that was at issue in Lopez, and there's the violence against women sort of statute that was at issue in the Morrison case. You could easily say how you could sort of frame the the school-free zones tax, whereas if you are, within a school zone, you get to pay some massive tax unless, you don't have a firearm, however you would structure it. Or if you want to engage in gender-motivated violence, you either have to pay, a tax of $700,000 or go to jail. I mean, yes, but I think as a practical matter, the ability of Congress to call something a tax and have it be popular is much lower than having the free lunch rationale that the Commerce Clause gives. And as a practical matter, I think there is more to be concerned about the ability of the court to call it a tax afterwards when it was proposed and defended on the theory that it was not a tax. What some of the lower courts had said in saying that this could not be upheld as a tax was that, the Constitution is very careful about taxes. For example, all bills for the origination of revenue have to start in the House rather than the Senate, for example. And that is because there is a sense in the structure of the Constitution that you have to have a certain level of accountability for the raising of taxes. And what this sort of ruling does is evade the accountability that the political process provides for the raising of taxes by allowing elected representatives to claim that a tax isn't, except when they want to defend it in court.